On whether public participation was undertaken, the petitioners argued that the enactment of the Act was not done in conformity with the various tenets of the Constitution, one of them being public participation. While they concede that some measure of public participation was conducted, it was their submission that it was not sufficient. It was therefore their case that at best, what was done was a cosmetic exercise and a waste of public resources. The petitioners argued that whatever was done by way of public participation went contrary to Articles 10, 118, and 201 of the Constitution. In particular, the petitioners argued that the invitation notice to members of the public to present memoranda on the bill by the National Assembly within 7 days was too short, and thus the purpose of public participation cannot be said to have been achieved. Similarly, they contend that the deliberations of the Senate at the second and third reading stages was also constrained, with the result that it limited public participation to 7 days only, such that no public hearings could be conducted in any of the 47 counties. The petitioners also took issue with the fact that public participation was only conducted in 19 counties. They pointed out that 28 counties were excluded from the exercise in blatant violation of Article 10(1), 2A, and 27 of the Constitution. That the petitioners went further to state that the discrimination of the 28 counties and the refusal by the committee mandated with the conducting public participation or collecting views of the persons from the 28 counties was in blatant disregard of Article 47 of the Constitution of Kenya 2010, as read with Sections 4 and 5 of the Fair Administrative Act 2015, that require administrative action to be expeditious, efficient, reasonable, and procedurally fair. In addition, the petitioners submitted that although public participation was conducted in 19 counties, it was non-quantitative, non-qualitative, and therefore rendered meaningless. It was argued that public participation was conducted only in 19 counties, while the National Assembly executes its mandate in 290 constituencies. The petitioners further argued that lack of proper public participation is evident from the reports of the National Assembly and the Senate. It was their case that the National Assembly and the Senate did not provide adequate opportunities for people's involvement in the legislative process of the Affordable Housing Act. In the same vein, the petitioners also submitted that Kenyans had legitimate expectation that the Constitution would be followed in conducting public participation. In conclusion, the petitioners urged this court to find that the Affordable Housing Act did not meet the constitutional parameters for public participation under Articles 10, 118, and 201 of the Constitution. In their response to this question on public participation, the respondents did not dispute that public participation is a requirement of the Constitution. To illustrate, the National Assembly indicated that it conducted civic education in languages comprehensive to the diverse communities in various locations before public participation sessions were conducted by providing fact sheets that gave information to the Affordable Housing Bill. In addition, advertisements in the local daily newspapers were done inviting the public to submit views on the bill by the deadline of 28 December 2023. Key stakeholders were invited to participate to make oral presentations before the committee in sittings that were held in Parliament buildings on 29 and 30th January 2024, 6th and 7th February 2024. The respondents submitted that public hearings by key stakeholders were held on diverse dates across 19 counties that included Narok, Kisii, Homa Bay, Vihiga, Uasin Gishu, Turkana, Baringo, Nyandarua, Nakuru, Machakos, Kirinyaga, Embu, Kiambu, Wajir, Tana River, Lamu, Kilifi, Mombasa, and Nairobi County. Additional meetings were held on various dates with the State Department of Housing, the National Treasury, and the State Law Office, among other government agencies, that allowed various agencies to make presentations to the joint committee. It is the National Assembly's case that it received and reviewed written memoranda submitted by the public and invited stakeholders. It is further the National Assembly's case that the majority of the stakeholders were overwhelmingly supported the bill, noting that promotion of investments in affordable housing has a multiplier effect on the economy through creation of employment, improved supply chains for the construction materials, and consequently will improve the general public. According to the National Assembly, the assessment of Parliament's compliance with its obligation to facilitate public participation in the legislative process is guided by the principle of reasonableness, and there is sufficient evidence to demonstrate that the Act was procedurally and legally subjected to public participation per the Constitution and the standing orders of the House. As a result, the National Assembly urged this court to find that the Affordable Housing Act was compliant with the provisions of Article 10 and 118 of the Constitution. The National Assembly and the Attorney General alleged that the question of public participation had already been determined by a court of concurrent jurisdiction in the case of Appeal versus Attorney General and two others, that is the Kisumu petition, on February 29, 2024, where the court found that public participation in respect of the Affordable Housing Bill was compliant with the provisions of the Constitution. The Senate also asserted that the public participation in the Act was conducted by the law and the standing orders, and there was no requirement for public participation in the 47 counties as alleged. It denied that senators were gagged from fully and freely debating the bill and argued that there was no proof provided to this court by the petitioners to discharge that duty. On their part, the KRA indicated that the rate of 1.5 was picked, which was picked from the Finance Act 2023, was on reasonable grounds that it had undergone proper public participation, channels, stakeholder engagement, and the rationalization process, which proposed a reduction of the rate from the initially proposed rate of 3% to 1.5%. It was their case that the High Court judges did not counter the constitutionality and validity of the rate in the petitions challenging the Finance Act. The respondents' assertion that public participation was conducted within the principles of the Constitution was supported by the 10th respondent. I think this is the 10th interested party, COFEC. It was the COFEC's argument that the public participation was conducted within the confines of the Constitution, and that the opinions of Kenyans with regard to the provision of the collection of the levy of affordable housing by the state were considered before the impugned law was enacted. Having considered the foregoing arguments, it's important that this court first dispenses with the issue on public participation being res judicata in reference to the case of Appeal. The respondents have stated that the issue of public participation at the National Assembly ought not to arise in this case, as the court already determined that it was compliant with the provisions of the Constitution. Conventionally, the doctrine of res judicata is designed to bring finality to litigation and to provide parties with closure and relief from the burden of being troubled or pursued in connection with issues and lawsuits that have already been resolved by a court of competent jurisdiction. And this is the holding in the Supreme Court in the case of Kenya Commercial Bank by Mwiri and Mwiri Coffee Estate Limited. I will not rehash what the Supreme Court said. The Supreme Court also reaffirmed on the side case and cited the case of John Florence Maritime Services and another was the Cabinet Secretary of Transport and Infrastructure, where it goes on to explain the principle of res judicata. The Supreme Court held that a court has discretionary powers to interrogate the matter before it and determine whether it may occasion substantial injustice to the parties, and in the alternative, it must be convinced that there are special circumstances that allow it to make exceptions to the doctrine of res jurisdiction. This court has perused the appeal case and noted that the petition before the said court was pegged on the impugned notice dated 9th December 2023, issued by the National Assembly in the local dailies requiring public participation by way of submissions of memoranda for the Affordable Housing Bill number 775 of 2023. The said court noted that the petition only challenged, this court noted that the petition only challenged this mode of public participation on the ground that marginalized communities or persons living in the slums of Korogosho, Mathare and Kibera were not able to submit memoranda in the manner prescribed. The court has also looked at the issues raised on public participation in the 6 petitions, herein vis-a-vis the issues raised on public participation in the appeal case. It is our considered view that the issues raised in the instant petitions raise a broader question as to whether public participation was conducted at the National Assembly and the Senate within the tenets of Article 10, 118 and 201 of the Constitution, while in the appeal case the issue was specific to the mode used to conduct public participation. In any event, the court found that the issue was not ripe for determination, as the National Assembly did not only require submission of memoranda but also held public hearings as a mode of public petition. And we've cited the decision at paragraph 47 and 48 and 73 of the appeal court. We find the circumstances that the issue of public participation is not res judicata, and now proceed to consider the issue substantively. It is undeniable that public participation is essential to the legislative and policy functions of government, both at the national and county levels. Public participation is integral to the legislative enactment process. Under Article 10(2)(a) of the Constitution, public participation is one of the key national values and principles of governance. Article 118 of the Constitution provides as follows: Parliament shall A, conduct its business in an open manner, and its sittings and those of the committee shall be in public. Facilitate public participation and involvement in the legislative and other business of the Parliament and its committees. Failure to ensure public participation is fatal. Any action requiring it that proceeds without such involvement is invalid, as it violates an explicit constitutional mandate. This was the holding in the case for Doctors for Life versus the Speaker of the National Assembly and others. I think this is a South African decision that is widely cited. We are certain that public involvement was crucial prior to the enactment of the Affordable Housing Act. Public participation must be authentic, not just symbolic, and should not be treated as a mere formality to comply with constitutional obligations. It is important, therefore, that this court answers what defines proper and reasonable public participation as envisioned in the Constitution. We cite the decision in the South African case of Minister for Health and another versus the New Clicks, South Africa, where the South African court held that the principles of fairness are not to be applied by rote identically in every situation. It cannot be expected of the lawmaker that a personal hearing will be given to every individual who claims to be affected by the regulations that are being made. What is necessary is that the nature of the concerns of different sectors of the public should be communicated to the lawmaker and taken into account in formulating regulations. End of quote. Public participation does not necessarily mean that everyone must express their opinions. Instead, there should be tangible evidence of a purposeful initiative to incorporate a variety of perspectives in the participation program. This was as held in the case of Mui Coal Basin versus or interprets the Constitution. B, enacts, applies or interprets any law. Or C, makes or implements the public policy decisions. As aptly stated by the Appellate Court, public participation is anchored in the principle of the sovereignty of the people that permeates the Constitution, and in accordance with Article 1.4 of the Constitution, is exercised both at national and county levels. The court went further to reiterate this principle in the case of Aura versus Cabinet Secretary, Minister of Health, and the National Assembly has argued that the invited members of the public to take part in the exercise, which was conducted by the Joint Committee of the Department on Finance and National Planning and the Departmental Committee on Housing and Urban Planning, Public Works and Standing Committees on Roads, Transport and Housing, respectively. Both these committees and Standing Order 127 of the National Assembly Standing Orders, which require the House committees considering bills to facilitate public participation. That the National Assembly reached out to key stakeholders, inviting them to participate in public hearings held across the 19 counties on various dates, and this was not the only form of public participation, as there was nationwide collection of memoranda and public meetings in chambers of both houses. That from the 9th to 16th of December, the National Assembly collected public memoranda, which was collected nationwide. During this period, Petition 103 of 2023, that's the appeal case, was filed, leading to an order from the High Court in Kisumu prohibiting public participation as prescribed by the published notice on the 9th December, pending the determination. Subsequently, the High Court in Kisumu temporarily halted the collection of public memoranda, but this did not stop the other forms of public participation which were ongoing. On 17th January 2024, the High Court clarified that its order applied only to collection of memoranda by the National Assembly. On the 29th of February, the High Court in Kisumu ruled that the notice issued by the clerk of the National Assembly was valid, dismissing the petition. The court affirmed that the National Assembly had conducted public participation in a constitutionally compliant manner. This determination by a court of concurrent jurisdiction found that the National Assembly carried out public participation in accordance with the law. Based on the court's decision, it was concluded that public participation, that is in the Kisumu case, had been properly conducted. We note that on the National Assembly extended its invitation to stakeholders through letters dated 11th, 13th, and 29th January 2024, requiring them to make oral presentations before the committee. These sessions were held on 29th and 30th of January 2024, as well as 6th and 7th of February 2024. We further note that the National Assembly that held consultations with various government agencies, including the State Department of Housing and the National Treasury and the State Law Office, offering opportunities for them to submit representations to the joint committee. This is to be found in the affidavit of Samuel Njoroge, Clerk of the National Assembly. The National Assembly then reviewed the written memoranda submitted by the public and invited stakeholders. A report detailing this consideration was annexed to the affidavit of the said Samuel Njoroge and marked as SN1. The bill underwent the second reading on 15 February. During that time, debate by members of the National Assembly took place, discussing the nature and effectiveness of public participation. The ASAND report, which is annexed to the pleadings, details a report of the session of 15 February, which is attached to the pleadings here as SN2, and the documents this discussion. The bill was passed with amendments on 21st February and subsequently referred to the Senate in accordance with Article 110 of the Constitution. We also note that in line with Article 118 of 1B of the Constitution and Standing Order 145 of the Senate Roads, Transport and Housing Committee invited the public to submit written memoranda. This invitation was published in the Daily Nation, the Standard and the Star newspapers on the 23rd February 2024. These submissions were annexed to the pleadings and marked as JN1 to the Senate's response by an affidavit by Jeremiah Nyengenye, Clerk of the Senate. We note that the Senate conducted, through its Committee of Transport, Housing, also sent invitation to key stakeholders to appear before the committee for public hearings on 1st March 2024. The invitations were marked and annexed to the Senate's response as JN2. The Senate Roads and Transport Housing Committee reviewed the memoranda and stakeholder submissions. After considering various proposals, the committee's recommended that the bill be adopted with the proposed amendments. These views were annexed to the Senate's response marked as JN3. On 12 March 2024, the Senate passed the bill with amendments. The bill was then transmitted to the President for assent, which took place on the 19th of March. It cannot be denied from the foregoing that the public participation was conducted. As shown, the National Assembly and the Senate focused on very targeted and specific stakeholders. In particular, the petitioners. We note that petitioners took issue.
The fourth will be Honorable David Munyi Madenge. Fifth will be Peter Gichobi Kamoto. Sixth petitioner will be Grace Modoni Mwangi. Clement Mochiri Moriuki will be the sixth. And the seventh will be Edwin Munene Kariuki. The respondents will appear as follows. First, to the fifth respondents, as they appear in E565 of 2024, that is the Speaker of the National Assembly as the first respondent, National Assembly of Kenya as the second, Speaker of the Senate will be the third, Senate of Kenya will be the fourth, and the Honorable AG will be the fifth. H. William Ruto, the President of the Republic of Kenya, will appear as the sixth respondent. And the interested parties, the first interested party will be LSK as first interested party. There is the second one. The second one will be Professor Kithure Kindiki as the second interested party. Unless there's a party which is left out.
Just a minute. Is there anybody who has been left out on the quorum to amend consolidated petitions? Yes.
Moto and Company Advocates. I was left out in the morning in petition E013 of 2024. I had not been notified, and therefore I learned of these proceedings on the Nation TV, and I decided to come. So therefore, yes, I came all the way from Kirinyaga because Judge Richard Mwongo was very clear that we are going to be notified once the file is forwarded before the Chief Justice. There was no communication. So we were left stranded. What is happening? And our petition is being mentioned here today. And therefore we have had to rush very fast so that I can make it in the second session, that afternoon session. Therefore, I wish. Yes, maybe perhaps we can be.
Petition E13 and E14, Kagwea.
Yes, it was consolidated and we were told that we are going to be notified. However, we were not notified. I just learned of it today on the TV at 11. So we had to rush very fast from Kirugoya so that we can understand what is happening and perhaps clarification purposes.
Is there anybody who has been left of the out of
my own information?
Yes.
Just to draw the court's attention, there is an application lodged on behalf of an interested party in the name of United Democratic Alliance, which can be considered at the appropriate stage.
Intended interested party or interested party?
It's an intended. He has not been joined us yet.
On the parties?
Yes.
In this petition, I'm assuming it's one of those that you have mentioned.
You have not mentioned that petition.
Oh, okay.
And on that score, let me say this, that in the morning there were parties who had mentioned different petitions which were not before us. I think we should be very clear that we can only deal with matters which are before us. Should there arise a need for us to mention any matter which is not before us and which has been placed before us, we shall make that communication. So I think we need to be very clear that our jurisdiction is prescribed to particular files. Thank you very much.
My lords, you have made it. Permit me to request that the petition and E015, in which the Deputy President is the first interested party. Let the record of this honorable court show that we were not given an opportunity to be heard
on the issue of consolidation. Let the record show the court has acted of its own volition when the normal practice, even under the Mutunga rules, is to accord parties to state their views on a proposed consolidation. This is the court's own violation. We were not asked to give our views. Thank you.
Your Lordship. Your Lordship, we have had the orders that have been granted by the court, consolidating the matters and creating another lead file. And that creates the problem we were trying to address in the morning, Your Lordships. That now this bench has created 2 lead files. We have 522. Which files are not before you? We have now created another lead file, E565. Your Lordship, those are some of the issues we were trying to raise in the morning. That if those other files were before you, this confusion would not be rising.
Mr. Legwa, there is absolutely no confusion matters. Let us not bring confusions where there's none. I think in terms of consolidation, we have cited the rule under which we have acted, Rule 17 for avoidance of doubt of the Mutunga rules. I think we need to move forward.
Yeah, and my lords, on behalf of the respondents, we confirm has already been taken on issues that are not of any substance. Save, we would like to make 2 proposals. First, we would like, my lord, having read what has been filed by our colleagues this afternoon, we would like to propose that their application for recusal and this application questioning how the panel was put together should be had together for the very simple reason that they rely on the same set of arguments and facts. And I draw your attention to paragraph 5. They say that the impartiality of this court, the one we are before, has been questioned. And at the end of their prayers, they say that it is therefore in the interest of justice that this honorable court recuse itself. It would be gravely injurious to the respondents if they were allowed to prosecute this application, take one bite at attacking the court, and however the court rules, bring the other application for recusal and take a second bite. We would like to argue both of them together. Secondly, we would like an allocation of time, because it is quite clear to us that in the absence of directions allocating time, we are going to have another long afternoon of long-winded speeches that do not address the specific issues. We are willing to say in advance that whatever time you give us, if you give 10 minutes each, we shall accept. If you give 15 minutes each, we will accept.
Professor Giffey,
Yes, my lord.
applications have been filed.
How
How many applications?
the one you directed, my lord, in the morning.
Yes.
Yes, but it is in that application that has been filed by Jindo Matiba and Company Advocates. That is the application that seeks, on the one hand, that questions how this bench was appointed, and on the second hand, it requires the recusal of this bench.
So for avoidance of doubt, it is one application.
It is one application.
There are three applications.
But there is an earlier application for recusal. Yes. And that's why I'm saying we probably can hear both of them together.
Yes.
I'm sorry, my lord, but my lordships and my lady, I just wanted to remind the court of Article 159 of the Constitution. In exercising judicial authority, the courts and tribunals shall be guided by the following principles. And 159(2)b, justice shall not be delayed. So I'm requesting your lordships and my lady to kindly refer to that provisions and let us move forward. Thank you.
My lord, let it come on record that this is the first time in which, on a matter of extreme national importance, we've been given 1 hour to be able to do an application, serve it, and come back to court. We have tried to do the best that we could in terms of complying with those directions. Of course, one of the issues that we could not be able to do is that the written application could not be able to do full justice to the instructions that we've been given. And therefore, my lord, when Professor Gedhu Muigai stands senior counsel to say that we need to be gagged on the issue of time, we protest. We shall require sufficient time. This sufficient time is not forever. This sufficient time, at least for purposes of the three presenting the one other application, is 1 hour. It is the least that people deserve in an application of this nature. Secondary issue, my lord, is the issues of consolidations. Those issues of consolidation are as different as UDA can be from Jubilee. And the issue is, for purposes of the difference, the application under Article 165, and we did not hear you talk about the inclusions, because we've had to include. Their earlier complaint in the morning.
I'm sorry to say this.
I have.
Yes, I want to interject. If my learned friend is appealing against your orders, then there is the right forum. My lords and my lady take charge.
There is no, I'm responding to what has happened. Let us be fair to each other. And my lord, what I'm saying is this, that for purposes of those applications, the application under Article 165, because in the morning when we raised the issue orally, the questions that was raised, you are raising issues against the Deputy Chief Justice, who is not a party. She is a party now, and we have served her. We do the application on the issues of the constitutional violations regarding the empanelment of this bench. We shall need the court's directions on that issue. And we've gone through the authorities within the short period that we were here. So we are standing on solid grounds. We just need sufficient time to do our business. Issue number 2, my lord, if that applications were to succeed, then it would effectively mean, as my learned colleague Mr. Ngoya had indicated, that then the issue of recusal of your lordships becomes academic. But if your lordships were to hold that all these serious injustices that the petitioners allege were committed by the Deputy Chief Justice are okay, then we shall now address you, the issues that concerns you. And I need to add, on the issues of authorities, because now we've been told different instructions. When we came here, we thought that while we were proceeding and taking directions, prepare the team in the office, let them prepare authorities to argue on the issue of recusal. When we were given 1 hour, We told them, oh, stop on the issues of recusal. Now we are dealing with another thing. So, my Lord, we cannot be able to argue, if it is today, we cannot be able to argue as expected by our client on the question of recusal. And there is no similarity of issues. Therefore, my Lord, I urge you that let us adopt fair procedure. This fair procedure has always been there.
Specific application for recusal.
There are two applications.
Where are they?
We are not.
At least I know, therefore you mentioned one.
We are not.
We are actually bringing them even. One of them in number 0 is an application dated, I believe, yesterday, 21st of October. There is another one.
Okay, these are the directions we are making. We'll deal with the application before us. The application for empanelment of this bench. Where's the application? Where's the application? Empanelment.
Yes. Let's
perhaps before you give the directions, my line of is Kimotho. She's informing me that she was not aware of directions in the morning, that applications be filed and we come back before you. And now her petition is integrated in the consolidated petition, that is petition number E013. Therefore, she's not been able to file an application either for recusal or for challenging the empanelment. She was just requesting if she can be served with those applications and the responses, and she be given time, 1 hour just like the others, to file her similar application if she so wishes. Because now she's participating in a proceeding, she did not directions.
So listen to this and listen to this very carefully. All of us acknowledge the momentous import of the proceedings before us. And all of us are enjoined by the rules of natural justice to do what is right. This bench is not going to be taken round in circles. We will not be taken round in cycles. We are here to do justice for the petitioners, justice for the respondents. And anything which is intended to delay these proceedings will not be acceptable because both parties have come to this court under certificate of urgency. Let us be very careful how we argue our matters. We want everybody before us to get justice. That justice will not be possible if every advocate who stands up wants to take the cause in cycle. We will not allow that. I'm making final directions on this matter. The matter which we are dealing with is an application dated 22nd of October 2024 by Jindo Matiba and Company Advocates. It seeks orders under Rule 3 of the Constitution. We are dealing with the issue of empanelment. And then after that, we'll make a ruling for the way forward. So let us proceed. Let us be courteous to each other. Let us be courteous to the parties before us. Parties before us are very okay. But let's not be a theater by advocates to derail the process. I beg you. On the issue of time allocation, Judge Moreba will give the final issue directions on time.
Okay, this is how we'll proceed. The applicant.
It's only one applicant. It's only one applicant.
Any party in support of that application will have 5 minutes to support that application. And the respondents will have 7 minutes each to respond to the application, as well as any other party which will want to respond to the application.
We are aware that there could be parties who, for the good reasons given, may not have filed anything. But we also appraise ourselves of the fact that the issue before the court is an issue of law. Therefore, we'll give you time to make submissions on the issue.
May I please? The client, I and my colleagues represent the Deputy President, is the subject of the removal and the subject of his pleas to this honorable court for him not to be removed. The application for the constitutional bench is made in E015 by my friends Kiramugai, so that effectively the subject matter of removal is being given only 5 minutes. I plead with you, give us 10 minutes.
How long do you need?
20. 10 minutes. I would have said.
You have 10 minutes. You have 10 minutes.
Thank you.
Can I be heard? My lord, the country is in a crisis. There's a constitutional crisis. There is a national crisis. And our coming to this court is like commencing or opening an opportunity for healing in the country. And if I may say so with tremendous respect, this is not a matter where you should be allocating some 5 minutes, 10 minutes, 20 minutes. No, that is not suitable. Let these lawyers talk. They are part of the healing process to the 15 million of Kenyans. A number of them are glued now to radios and TVs, trying to hear what is being said in this court. And for this honorable court to come and say that my ever friend, Mr. Mute, will only have 10 minutes, will have no 5 minutes.
Mr. Mute asked for 10 minutes and we allowed him to have 10 minutes.
He said so because he was under coercion. Taking the trouble to read constitutions of other countries. In fact, the way things stand at the moment, the constitution law is evolving in such a manner that it's no longer confined only to Kenya. We can have a concept of international constitutional law. And if you read that law, including the American law, which I've taken the trouble to read, and which I've had access to it for many years.
Dr. Kamina, we made proposals. We gave directions. Apparently, you are not satisfied. What is your version? What would you want us? You want us to give everybody how much time?
My Lord, forget about the concept of time. Forget, where are we heading for? What are we heading for?
So, yeah.
Yeah, we want the country to wake up and to revive and to give the life to the country. The country is Kenya, if you don't know what I'm talking about.
Your Honor, let the lawyers say what they want to say. This should be part of the hearing process of the whole country.
Dr. Kameno, I ask you, we have given directions on time allocation.
Your hands are not tied with respect.
Okay, tell us, just tell us, in your view, how much time do you want us to allocate parties?
I'm saying to the my lord, we talk about time in the civil matters and so on. But we are dealing here with the issue of impeachment. Issue of impeachment of the deputy president. It's not a small matter at all. It's a matter that is starting the whole nation. It has paralyzed the nation.
We have heard you, Dr.
And let Paul Winter be given as much time as he wants. Let the professor be given as much time as he wants. Let the Honorable Attorney General be given as much time as he wants. That is the healing process. And from this court, we shall all march forward with confidence. If I may quote Mutajo Makinata, Kifua mbele ni matako nyuma. Let us talk about time. Where are we going?
My Lord,
where are we going? With respect, will you sit down, please? Kamino is talking. Will you sit down? I don't command the man on to call yourself. Will you sit down, please? I am talking. I am on the floor. My Lord,
under the rules of this court, senior counsel has preference, speaks first before any other person except the Attorney General. So if you would please sit down. I as senior counsel.
I will not speak down. You are practically you are still doing breastfeeding.
That is also true. So my Lord,
my Lord, what I'm saying,
finish what you're saying.
What I'm saying to you, my Lord, we need a healing process, and this court is going to provide that healing process. Let the lawyers say what they want to say. What are we hurrying for? Let us not have some people calling themselves professor or senior counsel titles that don't mean anything at all when it comes to this.
I think they mean something. They mean something.
Something means something when it's you and you approve it. Yes. My Lord, all that I'm saying to you, let people talk. Let people address you. Where are we going?
People will talk.
When the country is burning.
Dr. Kameno, you have made your point.
Yes, thank you very much.
You have made your point.
I have made your point.
Professor.
We have a executive chief justice who has been removed irregularly. Let us be given time to be able to address it.
My Lord, I think those of us who are representing substantive respondents, we all agree that you have given orders that we will comply with, including my learned senior PK Moite, who I believe you have added some more time and he's happy with that. Maybe it would help if we informed Dr. Kameno that it is not the whole matter that is being heard in 10 minutes. It's a very small slice of an application on empowerment. That's all I wanted to clarify.
So, Dr. Kameno, I've heard what you say. We'll stick to the time allocations, but in the event that one party needs more time, they will tell us.
When we come to substantive matters, let people say what they want to say.
I agree with you.
Yeah. Where are we heading to?
Thank you.
Yes. Thank you.
In view of that line of question, and I thank senior counsel, the senior most going by the Kenya law reports before you. May I?
By the way, mention my name. Mention
Dr. Kameno.
Thank you.
Madam, the report of the East Africa Law confirms that. Madam, the point I need to make, and I beseech you, because of the serious time that we had to prepare this application, I could only prepare for certain aspects of these applications. my colleagues, Professor Gada, and my colleagues, Wanjiro. Within the 20 minutes that you have allocated, I will say my piece. It is insufficient, but I'll try. Please give Ms. Professor Gada and Mr. Wanjiro 10 minutes each, and at the end, when we hear what the respondents are saying, you kindly give me, you didn't indicate, 20 minutes to do a rejoinder. That will enable us to be able to proceed without anybody feeling we want to be here forever. We don't actually want to be here forever. We want to deal with the business of the day. So that, that does not change any time allocations by more than 30 minutes. So I urge your lordship, I'm starting. Yes. So that I do 20 or gather 10, 20, because he has to deal with some authorities. I didn't get enough time. I'll start with 10, then I'll do the rejoinder. My lord, the application that is before you is dated today. It is supported by the affidavit sworn by, it is supported by the affidavit sworn by Honorable David Munyi Madenge. And for the record, all lawyers from Matiba, Ogada, Ndegwa, and myself, the record indicates we act for everybody without drawing any distinctions, because I believe there will be no time for that. So we act for all the respondents, for all the petitioners, for purposes of E015. My lord, before going on to argue this application, there is a small point that I wish to make regarding the issue of why are we having a situation where to everybody watching we seems to be following an unusual path. My lord, there is one simply substantive issue of procedure that we need to point out. The petitioners are before you on account principally of the violations of the Bill of Rights. The petitioners are also here on account of the relevant provisions of impeachment. The petitioners are before you, my lords, on account of the fact that the business that the framers of the Constitution ordered, one, for appointment of a nominee to take place within 14 days, and for Parliament to do it within 60 days, somehow happened within 4 hours. My lord, those are the principal reasons why we are here. And what is the immediate context? The immediate context, my lords, and why we are here is that when petitions are filed, the duty of this court under Articles 19 all the way to 25 is to ensure that it decides whether or not the violations as alleged by the petitioners has taken place. My lord, the way in which the law, and this is express positive law, requires that to be done is by way of a judgment. By way of a judgment is the only way that the people of Kenya would be satisfied. Have these rights been violated or not? In order to ensure that that judgment, which is the express constitutional mandate, is given in circumstances that are not academic, Article 23 of the Constitution provides that conservatory orders may be given. When this matter went before your brother judges, probably your sister also, in their wisdom, they directed this matter as such enormity that we need to preserve the subject matter. That subject matter, my lord, the preservation of it would be to ensure the relevant office remains vacant until this case, through a judgment, pronounces itself. But my lord, why are we here and why is there a heated discussion? We are here and we are having a heated discussion because what is the clear intendment of the Constitution is being circumvented, so that to ensure that the subject matter is not preserved. My Lord, this would be akin to a situation in which somebody comes and says, I am being evicted and my things are being removed. A court says, stop the eviction process up to where it has occurred. Then the respondent comes and says, no, lift those orders so that I can carry those things that it is alleged I was unlawfully taking. So that, my Lord, in the face of the fact that what conservatory orders are supposed to serve, I beseech you, and I believe the entire country would expect that there has to be preservation of the subject matter of the application. So that, my Lord, now, that being the context, it is absolutely important that we do not lose sight of the moment. It is heated, one, because there was a sitting on Saturday. Before application responses could be made, we found ourselves here. We were supposed to come here on Thursday. We are here on Tuesday. So that, my Lord, and there are a lot of matters that directions must be given. So that, my Lord, that context would be absolutely important, because when all is said and done, the critical issue before this court is a right under Article 25, the right to fair hearing and human dignity. Right to fair hearing and human dignity cannot be violated even during an emergency. My Lord, that being the background, I ask you, and we shall be asking you, because that is the context where all these things are happening, that you ensure that whether heaven falls, the High Court must stand up, if for nothing else, for the right to preserve the subject matter until this High Court pronounces itself through a judgment. Because that is express law. Having said that, my Lord, I come to the prayers. The prayers are like this, and we had already indicated. There are about 6 substantive prayers. The linchpin of these substantive prayers, my Lord, is the fact that the Deputy Chief Justice, under Article 165, does not have the power to appoint or assign, as the words used by the constitutions, members of a certain court to hear the matters. My Lord, Article 165(4) is very clear. Where the constitution says the president and Article 149 can nominate Kindiki, there is no argument that is made that a minister or somebody else can be made. We expect that there can be no feasible argument where the constitution has expressly said that the Chief Justice shall do something. The Chief Justice in this case did not empanel this bench. My Lord, we are urging this honorable court to make a finding that unless the constitution is interpreted or amended to give the Chief Justice, the Deputy Chief Justice, the power to empanel a bench by express reading of the Constitution, she cannot be able to do that. Issue number 2, my lords, is that it is not for nothing that it is one of the biggest occasions that the senior most judicial officer is the one that the people of Kenya, judicial power in the first place vests in the people. Judicial power by express words of the Constitution or to do this appointment and to act under Article 165 was vested of the Chief Justice. It is not by accident. It is by the express intention. So that, my Lord, on the face of it, when a state officer who is not directly mandated to do something ends up doing it, under public law judicial review, it is done every day. You did not have the power under statute or the Constitution to do that. There are so many cases, starting with Madho versus Republic. I think it was sometime in 1974, where somebody at City Council did something where the law did not allow that person to do that. So that, my Lord, all these cases we are aware of. So that, my Lord, as far as Article 165 is concerned, we submit that that is not possible. But, my Lord, this argument is developed a little bit further by the petitioners' applicants. Because the petitioners' applicants are saying that the Deputy Chief Justice, having usurped the powers of the Chief Justice, she proceeded to do two things. One, to sit at night to appoint a bench, and to authorize that bench that sat on Saturday to conduct their business on Saturday. My Lord, those are irregular, because as we are saying, this is not a matter of public emergency. Of course, it was a matter of public emergency before the National Assembly and before the Senate. But because of the timelines we've given you, my lords, it is not a matter of public emergency. But having found herself in that situation, she decided to treat this matter as one of public emergency. Then, my lord, she directs come and sit on Saturday. We have set out in our applications and in our affidavit. There must be certain circumstances under our laws, the High Court Administration and Organization Act, that can justify for any bench to sit outside on Saturday and Sunday. There must be express reasons. Those express reasons, as we sit here, are aggrieved. We still do not know them. And if we do not know them, every Kenyan who would be aggrieved by a decision made in these circumstances would have every reason to be concerned that from the word go, there was a conspiracy to commit injustice. My lord, all of you have been honorable members of the High Court. There cannot be, where there is no public emergency, for occasions to arise that for the first time you would effectively be accused. You engaged yourself in a conspiracy to undermine the constitutions and to defeat it in a manner that would amount to treason. So that, my lord, the point that we make is that in the absence of a public emergency, what has so far happened is not only just unconstitutional, but something that would amount to violation of the Constitution and something that would amount to violations of the Penal Code as far as the issue of observing justice is concerned. My lord, for argument's sake, we proceed to make that argument. Let's assume that there was an emergency. We submit there was none, but let's assume there was one. If there was an emergency, then it was incumbent upon the Chief Justice to read, and they were in the newspaper and in the news, all these cases that honorable judges of the High Court from various stations had recommended for a bench to be appointed to hear them, to consider them, and place them for hearing on Saturday, and to fast-track that hearing. But, my lord, what is it that happened? My lord, what actually happened is that you have a situation whereby the respondents, who are basically agents of the government of Kenya and its various appendages, have gotten their applications to be satisfied and for a bench to be specially convened to sit, because from the standpoint of the petitioner, to set aside the conservatory order in order, as the petitioners contend, the violations of the Constitution may be completed. My lord, justice in this case, if it means anything, it must mean a very simple issue. The multiple violations of the constitutions that are already ingrained and embodied in the various applications, we cannot allow them to be completed, because this is what it's all about. This is what the decisions of the Chief Justice was all about, to complete the serious violations of the Kenyan Constitution. By your oath of office, your lordships are committed to stop arrest for debt and the government and its appendages that act in this manner. My lord, what does it amount in law for the Chief Justice to say you have about 15 or 20 cases, as I hear from my learned colleagues who have been in this matter longer than me? I'm here today for this matter, and I'm here because there is a constitution in Kenya. My lord, that being the case, there has to be satisfaction. If the Chief Justice, and she's a party in this application, cannot be able to justify why did you choose to address the grievances of the Attorney General and the government of Kenya and leave the petitioners. The first right of hearing under our constitution, I deal with Mutuga rules every day, is that the petitioner will have their rights to be heard, to prosecute their case. That is what the Bill of Rights means. The respondent, even under Mutuga rules, will respond and answer the allegations that have been made. But my lord, where the Deputy Chief Justice chooses to fast track the grievances of the alleged violator, common sense has to be affected. My lord, the conscience of this court must be bothered. Such conduct in the normal sense of things. We went through the removal of judges during those days. There was just minor infractions of the right to be heard, and judges were shown the door home. But my lord, here, it is a systematic decision consciously made that would have very harmful effect for the jurisprudence of our country and for the meaning of our constitution. So that my lord, so that my learned friends can be able to speak for themselves, we are alleging that as long as the bench has been appointed by the Chief Justice who has declined to follow the fair process for purposes of appointment of the various judges to sit, there cannot be a valid appointment. Not because I and my colleagues here would have anything on a good day before any of you, your lordships. We have done very many matters. You have courageously stand up for the constitutions in various matters, but my lord, unhappily, we have to be the ones saying that it would appear to a section half of this country, if not 3/4, that you have been enlisted in service of the violations of the constitutions. My lord, that may not have happened, but that is the only way reasonable people would be able to interpret all this, particularly against the background that even the Gen Z were abducted. The substantive Chief Justice did not empanel a single bench to sit on Saturday or on Sunday. That is why this, but the context in which this matter must be viewed. My lord, there are certain authorities, my learned colleagues will go through them, but I need to mention at least two things. My lord, of course, the arguments would be made. I think there was some time back, probably in the Okio Mtata case, my learned colleague will clarify, where the Deputy Chief Justice, the same Deputy Chief Justice, made an appointment. There was no substantive Chief Justice at that time. There was a decision that was saying, this is administrative. That decision is not binding. But my lord, more importantly, now that this issue is arising directly, this court must retire, make a very reasoned decisions to settle this issue. Whether in every other case in which the constitution or statute says so and so will do this, if that so and so does not do it, without failure, the High Courts and the Court of Appeal have always held there was no jurisdiction. An order of certiorari have always issued. It shouldn't be different in this particular matter because the power belongs to the Chief Justice. Now, the second issue is a decisions, I believe, one of you was involved, and I believe it is a case of Okoliti Omtata versus JSC, and the decision in that decision was that at paragraph 29 to 38, basically it says that where there is a substantive Chief Justice who is a state officer, she does not cease to be a Chief Justice in this era of technology. And accordingly, the Chief Justice, the CJ, does not have authority under the constitutions to assign roles assigned to that office. So that, my Lord, in this case, even assuming that in writing the Chief Justice had assigned this role to the deputy, and that has not been alleged, it would still not be good enough. Because wherever that the good Chief Justice might be, this is something that she could have done as expected her. And the people of Kenya obviously would be interested because of the nature of this matter. Why would the Chief Justice abdicate to do her job and let her deputy to do her job in a manner that aggrieves the petitioners? That is an important question, because it is the job of the Chief Justice. There is a huge mandate that is given by the Chief Justice. Do your job with the entire authority that your office carries. So it cannot just be that it is for the Deputy Chief Justice who has usurped. It is also abdication. What would be the basis for abdication? The Chief Justice not to do their job. The other case of, just 1 minute, 1 second. The other case of, I think my learned colleagues, so that it can be fast, I don't want people to knock me. My learned friend can do her. Let him do his 10 minutes, then he can do his 10 minutes.
Thank you very kindly, my lords, my lady. I'll only highlight a few issues which are legal. I'll move from Article 1 of the Constitution, your lordships. That Article 1 has created organs of government. Among them is the organ of the judiciary. And it has clearly provided, your lordship, that the people of Kenya, in exercise of their sovereignty, they have delegated their powers to those organs. In this case, the power under Article 165, Clause 4, is exclusively delegated to the Chief Justice. Your lordship, in administrative law, it's right that a person who enjoys delegated powers cannot further delegate those particular powers. In this case, in this circumstance, your lordship, it is not known to the petitioners under what circumstances the Chief Justice may have delegated these powers to the Deputy Chief Justice. It is our humble submission, your lordship, that the powers and the functions under Article 165, Clause 4 are not capable of being delegated. Further to that, your lordship, you see clearly under Article 159 of the Constitution, which provides that, your lordship, that judicial power is derived from the people and shall be exercised by the courts and tribunals established by this Constitution for and on behalf of the people. That article again clearly indicates that this power under Article 165, Clause 4 is not capable of being delegated. How about, your lordship, in the Constitution? Your lordship, I invite you to look at Article 260 of the Constitution. It provides if a function has been created to be executed by that particular organ, it is only that organ that is capable of executing that particular function. And for the question of further delegating that particular function cannot arise so as to say that the Deputy Chief Justice had the constitutional mandate to appoint this bench to adjudicate over these particular files. Your lordship, we have put up a case that the Deputy Chief Justice has not only violated the Constitution, but also violated the rights of the petitioners to be heard under Article 50 of the Constitution. When they move to appoint a bench of this, the bench, and fail to notify the parties herein as evidenced by the counsel appearing for the petitioner in petition number 14, it tells your lordship that the expediency for which it was done was so as to meet the objective of setting aside the orders that were granted by your brother Justice Mwongo and your brother Justice Mwita. Your lordship, when you retire to make a ruling of our application, it is important that you pay serious attention to paragraph 12 of our affidavit, paragraph 21 again of the affidavit, paragraph 22 again, and also paragraph 27. And then you might want to ask yourself, under section 10 of the High Court Organizations, High Court Administration and Organization Act, how, under what circumstances the Chief Justice, the Deputy Chief Justice, authorize you to sit on a Saturday? Under what circumstances did the Chief Justice herself, Deputy Chief Justice herself, sit at night, in the wee hours of the night, and got the hours, and constituted this bench? Your Lordship, it's our humble submissions that Article 10 has only arrogated that function, again, exclusively to the Chief Justice. And that the Deputy Chief Justice has no power under Section 10 of the High Court Organization and Administration Act to order you or to authorize you to sit on an odd day like that or the Saturday. Your Lordship, permit me to draw your attention again to the case of Omtata. When you retire and the judgment will be highlighted by my learned friend, it is of importance, Your Lordship, that you look at paragraph 192 of that judgment. It has given the circumstances under which the Deputy Chief Justice can act in the absence of the Chief Justice. One is if the Chief Justice is indisposed, if he resigns, if he is dead, or if he is holded out of office. The question of leave, to which we are submitting without knowledge whether that is the circumstance that led to the allocation of powers by the Chief Justice, is not one of the grounds or reasons that the Chief Justice can exercise, the Deputy Chief Justice can exercise the exclusive powers meant for the Chief Justice. Finally, Your Lordship, all of these avowals contained in our affidavit have not been controverted by the respondents through a replying affidavit. They have only filed the grounds of opposition, to which they shall bring to your attention the case of Contena, which has been distinguished by the case of Okia Omtata. The grounds contained in our affidavit, Your Lordship, are uncontroverted and they must be admitted as such. I beg to rest my case.
May we request counsel to give us specific reference to Okio Mutata has been mentioned by two counsel. He's probably the most prolific litigator in the history of Kenya.
I will certainly be addressing my senior at the bar and senior at the academy, Professor Gideon Mugai, who is a pleasure being with him in court. A man or woman who plants a tree, not knowing fully well that they will not sit in its shade, knows the meaning of life. You sit today in such an epochal moment that what you do here has significant ramifications for the Republic of Kenya. It is for you as a court to rise to the occasion. This court has defined the Constitution as a transformative Constitution. And this was done by this very court, differently seated. In the BBI case, David Ndii and others, versus the Attorney General. And this is what the court said about the Constitution 2010. It is a constitution of a transformative character, and this transformative character of the Constitution induces large-scale social change, including the character and conduct of politics. That the Constitution bears an internal theory of interpretation. Starting point for discerning that internal theory is Article 259 of the Constitution. That formalistic approaches to constitutional interpretation are not favored. The other side has filed grounds of opposition, and in their grounds of opposition they raise a case, Lorna Conchella and others versus the Chief Justice. That was the grounds of opposition by the Attorney General. And in that case, this High Court said that the power to appoint a bench is administrator, and that power can be performed by the Deputy Chief Justice in limited, constricted circumstances, so that the normative holder, the Chief Justice, performs it, but the Deputy Chief Justice has to perform it in certain limited circumstances. Those limited circumstances have to be demonstrable. That is Conchella. Your Lordship, Justice Murima, sitting in Okoiti versus JSC and another petition, E408-2020, 2021 EKLR, I believe that is what Professor Didimugere was asking about. Paragraph 29 to 38. Justice Murima finds that the authority under Article 165(4) is a constitutional authority, so that authority cannot be delegated by the Chief Justice, because the Chief Justice does not cease to be a state officer, even on leave. We have another authority here, Petition 31 of 2013, Kenya Medical Research Institute versus the Attorney General. This is found at 2014 EKLR. At paragraph 37, Kenya Medical Research Institute versus the Attorney General and three others, 2014 EKLR. This case at paragraph 37 says this, that the Chief Justice under Article 165(4), the authority to empanel a bench, performs a constitutional mandate. And this is not an administrative function, as was in the old Constitution. Where do we go? I'll invite the court to look at the express wordings of Article 259(3)(a) that expressly decrees that authority granted to a specific office must be performed by that specific officer. That is Article 259(3)(a). I'll want this court to consider the decision of the Court of Appeal, and this, the other side can take judicial notice of, the court can take judicial notice of the case of Karisa Chengo, whereby the office of judge and the person of judge are synonymous, so that the Chief Justice, the person, and the office of Chief Justice are synonymous. And therefore, we cannot separate and delink the holder and the person. And therefore, if the Chief Justice were to delegate any responsibility to the Deputy Chief Justice, assuming that was possible, then the Deputy Chief Justice has to take an oath by virtue of Article 74 of the Constitution. There has to be instruments prepared authorizing the DCJ to act as Chief Justice, and for what purposes? Ladies and gentlemen, Honorable Court, the Greek tale of Ulysses, the coxswain who was asked to block his ears using wax and to avoid the temptation of alluring music, that story echoes well for you today. There's politics, there's a lot of heat and rancor, but for you, as the court, an apex court under the Constitution, yours is to uphold and defend this Constitution as required at Article 3. That's the sole mandate of this court. Thank you.
Clause 1 of the Constitution. Article 141, Clause 1 of the Constitution provides, and I read, that the swearing in of the President-elect shall be in public before the Chief Justice, or in the absence of the Chief Justice, the Deputy Chief Justice. It's very clear. It says who must do and what will happen in the absence of that person. Article 148, Clause 4 of the Constitution provides, and I quote, the swearing in of the Deputy President-elect shall be before the Chief Justice, or in the absence of the Chief Justice, the Deputy Chief Justice, and in public. Another very clear stipulation about our Constitution of what the Chief Justice can do and what will happen in the absence of the Chief Justice. Then we go to Article 165, Clause 4. I want to emphasize one thing, my lords, my lady. You notice that Article 141, Clause 4, Article 148, Clause 4 come before Article 165, Clause 4. The makers of the Constitution were aware of what would happen in the absence of the Chief Justice while drafting Article 141, Clause 1, Article 148, Clause 4. Let us see what they said at Article 165, Clause 4. They said, and I quote, that any matter certified by the court as raising a substantial question of law under Clause 3B or D shall be heard by an even number of judges, being not less than 3, assigned by the Chief Justice. Full stop. I'm always encouraged by an article my mentor, Professor Githu Muigai, wrote many years ago called Political Jurisprudence or Neutral Principles. Another look at the problem of constitutional interpretation. And Professor Githu Muigai makes an important argument that decisions of constitutional courts must be formulable in such a manner that they would apply coherently to all subsequent cases of similar facts. I'll not read these names in full, but you now know that if we approach this court and read for it Lena Conchela, the decision already alluded to, it will appear that this court's position is this power by the Chief Justice is administrative. If we approach this court and read the case of Kemri and the case of Omtata, both of which have been referred to by my learned colleague Mr. Ogada, you'll notice that the power under Article 165 is not administrative. The court says so, and my Lord Judge Murima, you contribute that jurisprudence. It is a constitutional imperative. I think my teacher, Professor Githu Muigai, would frown at that in jurisprudence as being political jurisprudence, because then we cannot answer first-year law student coherently. Is it administrative or is it not? We will find it difficult to answer it. Fortunately for you, as judges sitting here, you are not bound by those previous decisions, and you must come to the correct interpretation of the law in a manner that would address similar cases in the future coherently and without subjecting the judiciary to possible embarrassment. So then you will have to go and read what the two cases say, Kemri and Omtata, constitutional imperative, and what Conchela says, administrative. But then you look at the eventual verdict in Conchela, even when they say it's administrative, they set out the preconditions for that. And the question you want to answer is this, my lords: have those preconditions even been met, assuming even that you take it by administrative, for the Deputy Chief Justice to take up the tools of constituting a bench? Because that's the limited question that we are here to address and to guide this court. I make an argument that none of those grounds has been met. For example, we sat in this court in the morning, and I know this question will arise subsequently when we deal with the application for recusal, where my lords say, no, you know, in the virtual courts, in the virtual system, we can sit on anywhere. I'm trying to paraphrase it, my lord, so if I get one word wrong, it's not for any ill intention. We can sit at any time. We can sit from anywhere. We can sit on any day. So that, can the Chief Justice, for example, be virtually absent? Is it possible that the Chief Justice of Kenya distinguishes herself as the first person to be absent virtually? Wherever she is, at home, in Europe, in Asia, in Australia, in Kenya, wherever it is, can she be absent virtually? The answer is an emphatic no. That in the virtual space, it is difficult to justify absence. Is the Chief Justice disabled? At least, it has not been suggested by the applicant, nor the respondent, that the Chief Justice is disabled. And therefore, even looking at the Conchella decision, none of the preconditions cited there to justify the limp of administrative has been met, in which case the Deputy Chief Justice has no basis upon which she could have taken up the cudgels to constitute this bench. In a virtual court, my lords, and we must be very careful about this, because I kept asking myself this morning, I've never been a judge, maybe one day I will be, maybe not, how uncomfortable it would be to sit as a judge when you perceive that some of the parties believe are uncomfortable with you. It must be a very frustrating situation to find oneself in, and my sympathies go out to all judges who find themselves in those circumstances. Just 1 minute for this argument. But the interface between litigants at the judiciary in this technology space is the e-filing system that we are interacting with. None whatsoever. Is the judiciary immune from the principle of transparency and accountability? It is not. If the Deputy Chief Justice makes such a consequential move as taking up the powers vested expressly in the Chief Justice, that's a matter she must, number one, expressly disclose by lodging it in the CTS for us to interact with. Number two, provide reasons for taking up that role in that direction. We ought to have seen a decision saying, for the following reasons, I take up this role of the Chief Justice, then proceed to give directions. In the absence of that step, my lords, you have stood up as individual judges, as some of the greatest defenders of our Constitution. That character you have established in the past demands that you look at the Deputy Chief Justice in the eye and say, you may have